Good morning. Welcome to 2021 L&E Live Labor and Employment Seminar. My name is Brooke Khaleesi. I'm Practice Group Leader for the Labor and Employment Department based in the Denver office, and we're so very glad you were able to join us this morning. I can't tell you how much we miss our in-person events and the opportunity to visit with you one-on-one and catch up on what's happened within your organizations over the last year. And we are really looking forward to the day when we can resume those events. In the meantime, we're very happy to bring you virtually the latest, greatest, and most terrifying in the world of labor and employment law developments. A couple of logistics this morning. On the right side of your screen, you shall see a box that has chat, Q&A, and materials tabs. The chat is available to everyone attending the seminar today, so feel free to say hi to your colleagues. However, if you have a question related to one of the presentations, please use the Q&A function for that. Speakers will do everything they can, time permitting, to get to questions during the presentation. If we are unable to do so, then we will be following up with you on those questions after the seminar. So please send your questions our way. And then finally, the materials for today's presentation can be accessed through the materials tab. So without further ado, I would like to hand it over to John Doran, our esteemed colleague from our Phoenix department. John's vast experience and quick wit always yield extremely informative and entertaining presentations, and he will be handling the lofty topic of the U.S. Supreme Court this morning. John, please take it off.
Thank you very much, Brooke. Thank you all for being here, albeit virtually. I don't think I've ever had this many people in my house before. I'm thrilled to be part of this program. I'm thrilled to be part of an incredible group of labor and employment lawyers. So let's get on with the topic of the U.S. Supreme Court. Next screen, please. I always start with a couple of warnings and let you know what I'm going to be talking about this morning. First of all, in wine, there is truth. In PowerPoint, not so much. I absolutely hate drafting PowerPoints. You'll see I'm a very minimalist PowerPointer. What that means is I only draft my PowerPoints accompanied by a bottle of Cabernet. So if you see any typographical errors on the screen, blame the Cabernet, don't blame the speaker. We're of course dealing with a highly politicized environment right now. Everybody has a sense of politics these days that is sharply tuned and highly capable of being triggered. I don't hope to insult anybody's political views today. Please understand that if I do, first of all, I'm really sorry. Secondly, my views aren't necessarily those of Sherman and Howard. We had a very slow Supreme Court term, but it was a consequential one in a couple of respects. So this morning, what I'm going to do is talk about the new composition of the court, talk about decisions of the court that came down in the last term or so, discuss cases to watch and issues to watch. Next screen, please. Okay, the composition of the court. Brett Kavanaugh, of course, is a new justice to the court. He spent more than a decade on the DC Circuit Court of Appeals, which is, by some accounts, the most prestigious of all the courts of appeals. Despite his lengthy tenure there, he has no clear ideological bias in the employment space. Sometimes he found for employers, sometimes he found for employees. That was a little different when you look at his decisions with respect to employers versus the National Labor Relations Board. There tended to be a somewhat bias in favor of employers and against the National Labor Relations Board in his opinions. That was also true with respect to Brett Kavanaugh and ERISA cases. He appeared to be at least somewhat pro-employer when it came to ERISA issues. Amy Coney Barrett, the newest justice, she has a very limited judicial record. She wasn't on the Seventh Circuit all that long before being appointed to the Supreme Court. She has no clear ideological bias against or for employers. The important thing to note here is both Kavanaugh and Barrett are what we call textualists. They rule on the meaning of statutes based on what the statutes say, even if sometimes it seems readily apparent that the statutes say something other than what Congress intended to say. This could have some remarkable results in the labor and employment space. They could find meanings in statutes that we thought were plain from their face that are not plain from their face. They could strike down regulations that appear to interpret statutes in a way that is not consistent with the very specific textual reading of a statute. Of course, there's the Justice Breyer and the move to have Justice Breyer resign to replace him with a younger liberal justice who will be on the court longer. I don't see that happening anytime soon. Assuming Justice Breyer does step down, or heaven forbid, one of the justices passes away, President Biden hasn't released any so-called short list with respect to a replacement for any Supreme Court justice. We do know this much. President Biden did say during his campaign that he would for sure be the first US president to appoint a Black female to the US Supreme Court, but that's all we know. There is, of course, the current threat of court packing, the process of Congress adding 3 new seats to the Supreme Court. I don't think that's going to pass. I hope it doesn't pass. It's a major threat to the independence of our judiciary. Next screen. That leads us to the decisions of the court and the next screen. The first case I want to discuss today is Fort Bend County, Texas versus Davis. This is a case where an employer was in litigation for years before its counsel realized that the plaintiff failed to exhaust her administrative remedies. When she filled out her charge of discrimination, she didn't check the retaliation box. However, she filed a lawsuit that included a claim for retaliation. Years into the litigation, the employer moved to dismiss that claim for failure to exhaust an administrative remedy. The question presented to the court was, does Title VII categorically prohibit a lawsuit when the plaintiff fails to timely perfect a charge of discrimination? Surprisingly, the Supreme Court said no. And that's because, according to the court, a failure to exhaust an administrative remedy is a, quote, prudential, end quote, defense. Prudential defenses are subject to waiver by the employer. So if the employer doesn't assert the prudential defense right away, the employer could waive the defense. More importantly, the court said that the charge filing requirement in Title VII is not jurisdictional. It doesn't automatically prevent a court from hearing a claim simply because the charge filing requirements weren't met to the letter. This is problematic for employers and for those of us who represent employers because we face a barrage of the dog ate my homework defenses from plaintiffs who claim that there's a reason, a really good reason why they didn't finalize their EEOC charge. Things like the EEOC never called me back, which is a case we're litigating right now. Or I thought I signed my charge, I just forgot to sign it. Or I had a cold and I couldn't get into the EEOC, that's why I didn't perfect my charge. The end result is to, in a lot of ways, gut a process that is part and parcel of Title VII and minimize or marginalize a defense that we regularly assert in these cases. Next slide, please. Next case is Bostock versus Clayton County, a significant issue that's been percolating for years and years and years. Does Title VII prohibit workplace discrimination because of sexual orientation or gender identity? Answer, yes. To quote the court, it is impossible to discriminate against a person for being homosexual or transgender without discriminating against that individual based on sex. This is truly textualism versus legislative intent. Think about it. Back in 1964, when Title VII of the Civil Rights Act was passed, we lived in a very, very different era. The notion that the very same folks in Congress who tried to kill Title VII by adding protections for female workers, hoping it would get voted down, were the same people who voted for a statute that would protect sexual orientation or gender identity is simply mind-boggling. But the text says what it says, and that's the importance of textualism versus reading a statute in terms of what the legislature intended. This is a result that was very much predictable over time. It was just a matter of time before we got to it. Next slide, please. Comcast versus NAOM. This case asks the question, does 42 USC section 1981 require heightened pleading and proof of causation? First of all, let's talk about what section 1981 is. You hear about Title VII and the ADEA all the time. you rarely hear about Section 1981. Section 1981 is a post-Civil War era statute that was meant to protect only people of color. So Section 1981 prohibits discrimination on the basis of race in the making and enforcement of contracts. How is that different from Title VII? Well, it's different for several reasons. First of all, Section 1981 only covers race and ethnicity, not gender, religion, anything else protected under Title VII. Second, Section 1981 only prohibits intentional discrimination. There's no such thing as an adverse impact claim under Section 1981. Third, Section 1981 has a much longer statute of limitations. It has a 4-year statute of limitations. Fourth, Section 1981 doesn't require a charge to be filed with the EEOC. Fifth, Section 1981 is not limited to employment. It involves any contract that involves racism, whether it's employment or otherwise, and that's important, as I'll explain in a moment. And sixth, Section 1981 does not have a damages cap. So there are a lot of reasons why plaintiffs would bring race discrimination claims under Section 1981 instead of or in addition to Title VII. The thing is, a lot of plaintiffs' lawyers don't get that. We don't see Section 1981 claims a ton these days. So what did the court say? The court said, yes, Section 1981 requires what we call but-for causation, both when it's pled in the complaint and when you have to prove it either at summary judgment or at trial. But-for causation is a very strict causation standard. It applies or it requires an individual to prove that race was the reason, not a reason, as opposed to Title VII, which says all you have to do is prove that race was a motivating factor for causation. Who cares? Well, federal courts do. As you'll see in a second, the Supreme Court has addressed causation twice this term. It finds that but-for causation is a much higher standard than a motivating factor causation. And therefore, it's very helpful for us to obtain dismissals in lawsuits or obtain summary judgment at the summary judgment stage. More importantly, who else cares? Independent contractors. Let's say you have a lawsuit brought by an individual who claims to be an employee, but you claim as an independent contractor. If you win that that individual is not an employee and therefore not covered by Title VII, that individual could still assert a claim under Section 1981 because it covers all contracts, not employment contracts. For that reason, it's very significant. Next slide, please. The next case is Babb v. Wilkie. Again, we're back with pleading and proof of causation. Does the ADEA protections for federal employees, not private sector employees, require a heightened pleading and proof of causation? Now, the Supreme Court several terms ago in the Gross decision had already decided that for private sector employees, the test for causation was but for, the much higher standard of proof. So why might the federal provision be different? It's all about textualism. The court said that the ADEA provision for protecting federal employees uses language on causation that's different than the language with respect to private sector employees. So the test, contrary to Gross with respect to federal employees, is a motivating factor is the test. Again, please note the court's repeated focus on the difference between a motivating factor causation and but-for causation. This is particularly significant when you think about the fact that several terms ago, the Supreme Court ruled that in proving retaliation claims under Title VII, the standard is but-for causation. These three cases taken together over the last term and a half remind federal courts that that's a very high standard and one that is worthy of dismissal of a case if not pled correctly, or summary judgment when there aren't substantial facts to prove that a protected category was, quote, the motivating factor. Next case. Our Lady of Guadalupe School versus Morrissey Beru. Title VII has a ministerial exception. The ministerial exception says that Title VII doesn't apply to employees of religious institutions. But that begs the question, does the ministerial exception remove Title VII protections for all employees of a religious institution or just some of them? The Supreme Court ruled in this case that no, it only protects some employees of it only carves out some employees from a religious institution for protection. The court said a rigid formula doesn't apply. Courts must use a multi-factor analysis to determine whether or not an individual is covered by Title VII when that individual is employed by a religious institution. Job titles, levels of religious education, those are factors to look at, but they're not determinative. The question is, does the employee work on matters central to the entity's religious mission? If the individual does, the individual is ministerial and not entitled to protection under Title VII. So take, for example, a Catholic high school janitor. That individual is probably entitled to Title VII protection, while a religious studies teacher at the same Catholic high school would not be entitled to protection. Next slide, please. Little Sisters of the Poor versus Pennsylvania. Can employers object to the Affordable Care Act's contraceptive mandate? Answer, yes. The interesting thing in this case is the court said that that's true when an employer is either a for-profit or not-profit entity. So even for-profit entities can claim religious freedom under the free exercise clause of the First Amendment and at least avoid some coverage of some federal laws. And you'll see between these two cases another theme that will rise again and again and again. And that's the impact of religious freedom on the one hand and the ability to regulate the workplace on the other. Next slide, please. Cases to watch. Next slide. California v. Texas. I am not an ACA wonk, and I don't pretend to be, but this case is pretty impactful. The question before the court next term, or possibly this term, is does the Affordable Care Act's minimum coverage provision violate the Constitution? And more importantly, if the minimum coverage provision is unconstitutional, does that torpedo all of the Affordable Care Act? The issues in play here include pre-existing conditions provisions, healthcare cost subsidies, expanded Medicaid coverage for young adults, preventative care coverage, and Medicare drug benefits. It's a blockbuster case that could have blockbuster results if, in fact, it invalidates all of ACA. Okay, next slide, please. The next case is Van Buren v. Texas, or Van Buren v. United States. And this is one of those things that happens to speakers that they just read. 45 minutes ago, the US Supreme Court ruled in this case. So this is no longer a case to watch, it's a case to learn about. And I had a lot to say about it in terms of what could happen, but now I know what happened and I'll share that with you. This is a very important case. The Computer Fraud and Abuse Act is a very important tool for employers to use to protect trade secrets. It's a federal act that criminalizes the theft of computer data under certain circumstances. In this case, a police officer was authorized to use a police and FBI database. So he had authorization to go into the system. He did go into the system. He used the information by selling it to a third party. That was unauthorized use. So he had authorized access, which he used for an unauthorized purpose. He sold it to a third party who turned out to be an undercover cop. The question is, does the Computer Fraud and Abuse Act protect against use of information for an unauthorized purpose when the user was authorized to use the information for a valid purpose in the first place? The circuit courts were split, and that split created a great deal of uncertainty for this critical weapon against employee disloyalty. The Supreme Court decided this morning on a 6-3 decision that Van Buren's conviction for violation of the Computer Fraud and Abuse Act has to be overturned. The court held that if somebody is authorized to use a computer system, their unauthorized use after they gain authorized access is not forbidden by the act. The curious thing here is it was a 6-3 decision, and in this day and age, we usually think we know who the three are. In this case, we didn't. The three dissenters in this case were Justice Roberts, Justice Thomas, and Justice Alito. Again, this is a very textual reading of the Computer Fraud and Abuse Act because clearly Congress intended to have a statute with great power and to criminalize theft of trade secrets, and this sort of guts that statute. Next case. or next slide. Yeah, there you go. Fulton versus City of Philadelphia. It's a free exercise clause case. It's not an employment case, but it could substantially expand the scope of constitutional protections for religious institutions in the employment realm, including religious employers. Next case, Badge Row v. Walters. That is just a procedural case. I'm sorry. Yeah, there you go. It's very quirky. We don't have to talk about it this morning. Next slide. Same thing with the TransUnion versus Ramirez. It's a class action case under Rule 23, and whether or not you can have a damages class when only a small number of the plaintiff class actually suffered damages. Issues to watch. Last slide, please. If you haven't figured it out, religion is going to be a very hot topic with this particular court, and it will be for a long time. Another hot topic will continue to be LGBTQ, the Affordable Care Act. And here's one that people aren't talking about, harassment law at this point. Just recently, the Supreme Court denied certiorari in a case, Collier versus Dallas County Hospital. That case asked the question, is the solitary one-time use of the N-word sufficiently severe and pervasive so as to create a hostile working environment under Title VII? It's interesting that the court denied cert, and it's clear that the issue will come up again for two reasons. Reason number one, Justice Kavanaugh, when he was on the DC circuit, held in a case that the N-word itself is the most pernicious word in any language in the world, and its use can never be justified, and it is automatically offensive and unlawful. Contrary to that, Judge Coney Barrett, in a decision when she sat on the Seventh Circuit, said that a single utterance of the N-word does not create a severe and pervasive hostile working environment. So you have two justices who firmly disagree on this issue, and certainly gives room for a group of justices to say, let's take a test case, let's hear it, and resolve the issue. Arbitration will continue to be an issue for the courts, at least until Congress does something about employment arbitration. I don't think COVID, disability, leave law, I don't think those cases are going to percolate up to the court this term. It's just too soon. But the court may grant certiorari on COVID cases this next term to hear them in the following term. And of course, we'll hear lots about presidential power and administrative procedure as a result of the previous administration's appeals of challenges to administration acts. Thank you all for your time. I'll answer your questions offline. Up next is my Denver partner, Emily Kaimig. She is one of our data privacy and data security gurus who will talk to you about employer IT policies and employer security. Thank you all very, very much.
Good morning, everyone. Thank you. Thank you for being here. Could I please have my slides come up? Well, let me just say, I, for one, am very tired of seeing my own face as opposed to your faces in person. I'm very tired of seeing my own face on Zoom calls, Zoom meetings all day, every day. But that really is at the heart of what I want to speak with you about today. When we started discussing earlier this year what would be the topics that we would present at this program, of course, heavy on my mind was COVID and the pandemic. And that is because as an employment lawyer, and as I'm sure you all are painfully aware, COVID really did change what the workplace looks like. COVID changed what employment looks like. And one of the ways it did that was to teach us that what we previously thought was entirely impossible is in fact possible. And that's the whole concept of, or now reality of, work from home or work from anywhere, remote work environments. And along with remote work environments, of course, comes the need to reevaluate all sorts of policies and practices and where expenditures go And chief among those policies that really need re-examining in the world of remote work are those policies that protect your electronic data, which I would venture to say is owned and managed by every entity represented here today. So let's back up just a quick second and talk a little bit about what COVID did to the whole work from home concept. I'm not going to go through these numbers in great detail, but you can see this is a report produced by Cisco based on a survey of a very broad range of industries and what is happening in those very diverse industries in terms of remote work. And you can see that after COVID, we are going to go to a much higher level than we had before COVID in terms of those people working from home. I think this slide really sets forth the most, maybe shocking is the right word, evidence or data, and that is that before COVID, organizations that had more than 50% of their employees working from home, it was only 24%. That number will be almost doubled after COVID. So a significant change that is increased in work from home. So Cisco, being in the data business, of course, was interested in what this meant for companies and their data management and protection. A very vast majority, 96% of the organizations polled said that COVID was requiring them to change their cybersecurity policies because of work from home. 68% said they will increase investment, and 59% said, and this is where we all come in, that lack of employee awareness is their top challenge. So I think certainly pertinent to this discussion is the systemic effects of work from home, and they have been great. Chief among them, and I say this because I have anecdotal evidence of it, but also there are many studies being conducted and published that illustrate that this is in fact the case. And that is that there is increased competition among employers in the labor market because of work from home. So if you're an employer based in Denver or you're an employer based in Phoenix, and you are pursuing that really hot commodity, well-trained, well-educated, well-experienced candidate, you no longer are just competing with other employers who want that same hot commodity candidate in Denver or in Phoenix. You're now competing with employers, potentially competing with employers all over the country. So employers whose businesses operate out of California or Texas or New York. And so that reality now, that we can have a company based in one location, but employees working in various others, implicates the need to understand how the various laws interact. Because if you have an employee who lives and works from California, the laws applicable to that person are very likely different than those laws that would be applicable to the folks working in Denver or in Phoenix. And that in turn then implicates the need to re-examine policies and how costs and resources are allocated to deal with those issues. So I think at the beginning of the pandemic, we all did really quite a remarkable job of transferring out of offices and group workspaces to a work from home or remote work environment. But it caught many of us unprepared to manage our electronic data, among other things it caught us unprepared to do. And so I feel like we've really been playing a game of catch up. And I think, because of the reality and having to make such an abrupt move to a remote work environment, that a lot of employers said on a wing and a prayer, we're just gonna trust you guys that you don't abuse the fact that you have access to that you have access to the private secure data that you have. And so that policy, while certainly understandable, was not, I apologize, I've lost my internet clicker here, was not a good one for many, because there was a release of data. Sorry, let me get back on here, to places it probably should not have gone. Who creates the risk that you may have precious, valuable data that escapes where it should be retained, that is by you? There's the internal threat, that is the employee inside who may be accessing and misusing and taking data. There's the departing threat, and that is the disgruntled employee who takes with him or her out the door valuable data when he or she leaves. And then there's the external threat. I purposely did not put in my slides a discussion of Van Buren, which you heard John speak about just a few moments ago, because it was pending and I wasn't really sure how to educate us all about what the use of the CFAA with respect to protecting sensitive information might be. But now we know, as of, I guess now an hour ago, that it really is not helpful with respect to the internal threat, and it's probably not helpful with respect to the departing threat. So the Computer Fraud and Abuse Act, which many employers have for a very long time, used as a means by which to litigate or prosecute claims against bad former employees, is really no longer available. That means of protection is now really only available in terms of those who are an external threat, what we think of as the classic hacker. What is at risk and why is it at risk? Really, any electronic data you have is at risk, whether it's proprietary business plans, confidential information, trade secrets, HR files, medical records, any sort of data that is used in managing your business or that relates to sensitive information of employees or consumers. And why is it at risk? Because all of that data translates into dollars. It's really valuable. So when and where are there risks? There are risks everywhere data is maintained or goes. So it's devices, it's networks, and it's in the cloud. And it is at risk anytime someone is able to or does in fact access it. So we know that there are a lot of problems. What are we going to do? There are categories of means by which we can protect data. And certainly very important among them is IT protection. So this is something that your technical folks work with you on, ensuring that when you have people working from home, that there is a secure VPN connection, that you have the ability to wipe devices if they are lost or stolen, or you have reason to believe that they have data on them that they should not have on them. And that applies both to company-owned devices and potentially to personal devices if those personal devices are being used for business purposes. Multi-factor authentication, passwords, partitioning sensitive data from other data on the network and making it accessible and password protected for only a few people to have access to. Pop-up notices to employees, for instance, when they're sending an email outside the organization, you can have a pop-up that says to them, oh, by the way, you're sending this outside of the organization. Do you really want to do that? It's important, though, in addition to having those IT protections, that you actually use them, because on paper, they're worth very little. And the Smash My Trash case really illustrates that. It's a case last year out of Delaware. And in that case, the plaintiff said, that the defendant had obtained and used trade secret and confidential information. And the court in the case disagreed. And the reason the court disagreed is because they said, smash my trash, you really didn't treat this as a trade secret. You didn't treat it as secret data. You didn't treat it as confidential. And one of the pieces of evidence that illustrates that is that you talked about this technology, you talked about these business practices during Zoom meetings. And those Zoom meetings were not password protected, and you didn't take an attendance to ensure that there was no one on the Zoom meeting that should not be there. So again, the policies are great, but if you're not actually using them in order to protect and message to the world that that data is important and private, then they're not doing you a whole lot of good. And then, of course, there's employee training, because human beings being what we are almost always the weak link that causes problems. There are agreements, or there are legal means by which we can protect sensitive data from misappropriation by employees and others. We can protect with the use of non-disclosure agreements and other restrictive covenants short of non-compete agreements, confidential information, trade secret information, sensitive business management information. And we can have these agreements not only with employees, but with contractors, and in certain instances, perhaps with potential business partners, because we don't want those potential business partners having access to that sensitive information and then taking it and perhaps using it in competition against us. There are certainly issues to consider when you are contemplating the use of a restrictive covenant, whether it's an NDA, which I put at perhaps the mildest end of the spectrum, to a non-compete, which I would put at the most onerous end of the spectrum. You need to make sure that your actions track your words. Again, if you want it to be considered secret or confidential, it needs to be treated that way. And you can bolster your words with IT protections and things like passwords. There are, of course, legal issues beyond the practical ones and beyond the technical ones that need to be considered. And so we start with trade secrets under the Defend Trade Secrets Act. That is a means by which employers can protect their sensitive trade secret data. And most states have an analog to the Defend Trade Secrets Act, which is state law that, that has as its intent to protect employers' trade secrets. But the first question, whether we're talking about the federal law or the state law, the first question that we confront is always, is the data really a trade secret? In the Amgen case, these two cases were decided just last year, one out of California, one out of Florida, and they really highlight this issue. In the Amgen case, the Amgen argued that their pharmaceutical product price increases were a trade secret and that they should not have to be disclosed. And in that instance, the court said, well, you're statutorily required to disclose that information to various state and federal agencies, so it can't possibly be a trade secret. And the upshot of that, of course, is that Amgen's competitors had access to the information. In the Digiport case, the plaintiff had designed a co-location center for computer hardware. And the design had been compiled based on various pieces of data that was available to anyone. And the question was, had the plaintiff put that data together in such a way that it would actually rise to the level of a trade secret? And while the court said it's a fact issue, and so you have to take it to trial, clearly the court has doubts about whether that is truly a trade secret. Other legal issues to consider, and when you're drafting restrictive covenants, whether it's a trade secret protection restrictive covenant or it's a non-compete, it's forum selection clauses. If things go sideways and you end up having to litigate under your restrictive covenant, where is that litigation going to happen? How are you going to make sure that you have, or that the court has, personal jurisdiction over the employee you're litigating with? You also need to be aware of states' public policies and the particular problem of California. And California is notoriously hostile toward any sort of restrictive covenant, but the Hooked Media case, again, decided just last year, really highlighted that. What happened in that case is that Hooked Media was in negotiations with Apple. Apple was considering acquiring Hooked Media. That deal fell through. 3 of Hooked Media's employees left, went to Apple, and guess what? They were doing a lot of work that looked like the work that Hooked Media had done. And in that case, the court ultimately said, we're not going to find that it is a trade secret violation that those 3 employees went to Apple and did the very same work, including drafting code that looked very similar to what Hooked Media had, because to do that would effectively mean that they were subject to a non-compete agreement. So that's a pretty earth-shattering decision. I mean, we think everything that comes out of California is earth-shattering, but this is particularly earth-shattering. And then there are also potential preemption issues if you are litigating a Trade Secrets Act case and you also have common law claims. There are, in addition to restrictive covenants and the Trade Secrets Acts of the federal government and various state governments, there are some state law protections. Civil theft is a potential claim that can be brought against employees who abscond with sensitive data. Conversion, state law trade secrets, laws that speak not directly to the Trade Secrets Act, but to confidential information in addition to trade secrets. And then there's the duty of loyalty, which is a claim that can be implicated where the employee is using or taking trade secrets while they are working, and while they therefore owe a duty of loyalty to their employer. So again, there are various means by which to pursue problems that arise when sensitive data is stolen by employees. But the starting point, because clearly no one wants to end up in litigation, so we hope not to be talking about those things, but the starting point is to make sure that you have policies and practices and protocol in place to avoid ever getting there. So that brings us to, what is it that we do in light of all of these issues? Well, the first step is to really conduct a comprehensive review of where your data is, what you're doing to protect it, what are the categories. You need to determine what are the categories of the assets and what each of those categories needs in terms of its proper protection. You need to identify areas of improvement in your IT processes as well as your HR processes, and to determine what investment, if any, needs to be made. Clearly, from Cisco's point of view, I'm sure they're thrilled to know that the vast majority of people polled think that they need to make additional technology investments in order to protect sensitive data. And then certainly in the event you decide to utilize restrictive covenants, you absolutely positively need to get legal counsel. And I don't just say this because I want you to call us. I do want you to call us. But this is too complex and important an issue to wing it. Certainly, this is not an issue where you want to go and Google a non-compete agreement, print it out, and have your employees sign it. That's not going to fly. The legal landscape is complex, and there's a lot at risk. So with that, again, I will thank you for being here today. I hope that we get to see your faces next year. And let me introduce my colleagues who will be talking to you about the latest and maybe not so greatest events in labor law. Patrick Scully. Patrick and I joined Sherman and Howard at roughly the same time in the 90s. And Patrick has been a wonderful colleague and mostly the labor law guru that we all go to when we have issues, and that takes very good care of our clients. And James Corte, who is a much more recent addition to Sherman and Howard, but an up and coming protege of Patrick's. So I would say in short that you are going to hear now from Patrick, the journeyman, and James, his apprentice. Thank you.
Thanks, Emily. And I'm sorry I photobombed your presentation. If anyone saw that, that was probably a little disturbing. And thank you, everyone, for joining today. I know this is a bizarre forum for everyone. I'm really pleased to have James Corte with me today. James has the honor, questionable honor maybe, of getting roped into many labor law cases with me. And we've been working nearly nonstop on organizing drives and NLRB litigation and federal court litigation, because I think it's a moment of great excitement for the union movement, maybe not so much for us who have to defend their various claims. So I'm thrilled to have James here, and James is rapidly becoming an expert in all facets of labor law. So he is a great resource for anyone who doesn't know him. Many of you already know James. So I'll let James speak for himself about these developments, but we're going to get started with the presentation.
Thank you, Patrick.
So we started out by saying that this is a battle on many fronts and that it's commenced. I think that you all have some sense, if you have any experience with labor law, have some sense of the fact that in the previous administration, organized labor was very, very upset with the way things were going at the NLRB, the way organizing efforts were flagging. And I think that there is a great sense among those in labor that they're trying to get back and come back and make themselves relevant again. And I feel like we say this almost every year. We talk about these things, and James hasn't been to too many of these presentations, but enough to know that we're almost promising the return of the labor movement. In fact, last year, there was an increase in the percentage of membership of labor unions in the American workforce, but that is only due to the fact that overall membership went down, but there was such a reduction in the workforce due to COVID that their relative percentage went up, but actual membership is going down. And I think that the administration has made it quite clear that it's very concerned with this development. They're very concerned with the fact that the labor movement does not have a foothold as it once did, as many of you know. Even when Emily and I joined the firm in the 90s, it was already 20 years out of the box. And you can look at these percentages and see 6.3% of the private sector workforce. So the administration has a great plan to create a task force, which is always great news for all of us, to and put the vice president at the helm of it to really look at ways in which the labor movement can be forced into your front or backyard, as it may be, and into your workforce. And what we've experienced, I mean, I'm a product of the labor movement, I'm a product of the NLRB, and I can tell you that in my experience working in this area, that employees, if they're being treated appropriately in the workforce, they just don't have a lot of interest in a third party negotiating for them. But that notwithstanding, there is this sense among labor that this is their moment. And I think we saw a similar sense back at the beginning of the Obama administration, but I think there's maybe a greater sense of urgency. So as a result of that, we're having approaches on various fronts from labor. The first, of course, many of you heard about the PRO Act, which is the Protecting the Right to Organize Act, which again is a piece of legislation not dissimilar to the Employee Free Choice Act, if you remember that piece of legislation back in 2008. The idea of the PRO Act is to increase, obviously, the opportunities for organizing, to remove the secret ballot election, to eliminate right to work in many states. Colorado is a state in which there is a modified right to work. Unions have to go through a second election in order to get the authority to negotiate for compelled union membership. Arizona is a right to work state. So this law would do away with that and allow unions to negotiate forced payment of dues as a condition of employment. It would eliminate the independent contractor, essentially, overturn the super shuttle decision, and effectively go to kind of a California model where almost everyone is considered an employee. There's really no such thing as an independent contractor. It would speed up elections, again, much like the initiatives under the Obama NLRB, and it would most importantly, gag employers. There's a section of the National Labor Relations Act that some of you may have heard of. It's called Section 8C, that protects the right of the employer to speak factually on the subject of union organizing. And frankly, that may be the only way that your employees hear the other side of the story, or hear the reality of collective bargaining, or hear about what the law actually provides. This PRO Act would effectively do away with that and prevent us from speaking. And of course, if only one side is speaking in a sales pitch or in a debate, that side is probably going to win, which is exactly what labor wants. The PRO Act, its current status is that it sailed through the House, of course, but is stalled in the Senate. And those of you who are watching this are probably looking with interest at the infrastructure initiative and other pieces of legislation where the administration has sort of vowed to weave in provisions of the PRO Act. So look for that in the future. Locally in Colorado, I don't know of any other state where we have offices where this is happening, but in Colorado, there was what sometimes is referred to as a mini Wagner Act initiative. And a mini Wagner Act means a mini National Labor Relations Act for the state to apply to counties, cities, municipalities, as well as authorities in Colorado, and to basically force them effectively to deal with unions or engage in collective bargaining if there is an organizing drive. What is really significant about this piece of legislation was that it goes well beyond the federal law in terms, the federal law, love or hate the NLRB, there's definitely some balance to the federal law insofar as it protects the right of employees to choose. There's some recognition of business property rights, et cetera. Under this Colorado Public Collective Bargaining Act, there is a right of access to workplaces. There is a, eliminating the secret ballot, card check. There is mandatory interest arbitration, of course, speeding up the election process, which is, again, can be by card check. In the Colorado law, they eliminate lengthy collective bargaining agreements. Sometimes when employers get organized, they negotiate long-term collective bargaining agreements to preserve labor peace. And of course, we wouldn't want to have labor peace in the workplace, would we, James? Absolutely not. We want constant disputes. That's what labor wants. So eliminate the ability to get to those collective bargaining agreements, and give also a private right to sue under the state law, which you don't have under federal law. That means that counties, municipalities, and authorities could be dragged into state court over potential labor law violations. And the capper, an unconstitutional provision that would provide for interest arbitration to resolve collective bargaining. The good news about this piece of legislation is that it has been hopefully postponed indefinitely, but I think it speaks to the level of really power that labor has in not only this state legislature, but state legislatures all across the country, and of course now in Congress and the Senate. On the other side, so this is a battle on many fronts. So we have the legislative approach, we also have the regulatory approach. The regulatory approach primarily we'll speak to is the National Labor Relations Board, and you'll hear lots about what's going on at the state from other speakers, including Carissa, and there's a lot of labor-friendly people there. But we're going to focus on the federal regulatory approach. And I think what's most significant that happened in the past year was the Biden administration came in and fired the former general counsel, Peter Robb, who, if you don't like Peter Robb because of his politics or because he likes employers, fine. But, you know, Peter Robb is a reasonably nice guy who was given his walking papers basically upon arrival of the new administration. And what was significant to me about that, despite the fact that it was arguably unlawful, I won't get into the weeds on that, but the staff around the agency, the National Labor Relations Board, were publicly celebrating the termination of their leader, you know, singing Ding Dong, the Witch is Dead, or whatever they do, but they're sending out emails celebrating that Peter Robb has been fired. His replacement is Peter Sung Orr from the Chicago region. Mr. Orr is the author of the Northwestern football decision, which irrationally, in my opinion, concluded that scholarship athletes are eligible for collective bargaining. That was overturned, as you may know, but he is definitely a friend of labor. Then the appointed individual who will pursue aggressive litigation is Jennifer Abruzzo, who spent many years with Communication Workers of America and was really second in command to Peter Griffin, who was Obama's general counsel, and of course instituted the great and terrible joint employer rule that said that basically if you have any indirect control over any term or condition of employment, you're a joint employer with the putative employer. This regulatory approach is also going to play out in the Biden board, the appointments to the Biden board, beginning with the newest appointment, which is Gwynne Wilcox. Last week, President Biden announced that Gwynne Wilcox, who is a longtime union side lawyer from Levy Ratner in New York City. Also, Gwynne, very, very nice person. Personally, I know her personally. She's great. She is the most unfriendly to employer lawyer that you could possibly have on the NLRB. I would not expect her nice personality to come out in any decisions. She is absolutely a friend to labor and has publicly complained about many of the decisions of the Trump board. So our expectation with Gwynne is that she will be very, very aggressive on turning back the clock, if you will. The board will turn over, for those of you who are watching these things, in August when Member Emanuel's term expires. At that time, there will be a Democratic majority and the other shoe will drop, as they say. So moving right along, and the regulatory approach, there is an increase in the use of I'm going to do my John Doran impersonation now. There's an increase in the use of 10J injunctions at the NLRB. What a 10J injunction is, imposing the final remedy of the administrative process at the beginning of the case. We've already had a 10J that was authorized in the Phoenix region against one of our clients. There was really no discussing it, frankly. They were ready to go to federal court and bring about the return of the union organizers at the beginning of the case, which you can imagine is a very, very significant remedy that really negates the employer's authority in the workplace. There's also already been a return to the fact that representatives in election cases at the NLRB are being reported to the Department of Labor as potential persuaders. Persuaders are individuals who speak directly to employees on the subject of union organizing, and there's a financial reporting requirement. This is a way to, again, increase pressure against employers to prevent us from speaking on the subject of union organizing, because of course, no one wants the facts about union organizing in this circumstance. Mail ballots have been prevalent because of COVID, and some of you have in fact experienced it. What James and I have begun to see is that mail ballots are being favored even when circumstances suggest that a safe in-person election can be conducted. Why do you not want a mail ballot as an employer? You don't want a mail ballot because guess who gets to visit your employees at home during the mail balloting period? It's not me and it's not James, it's the union organizer. And the union organizer can show up and there's no restriction on that. The only restriction is that the union can't collect ballots. But of course, when a union organizer visits a home and shows your employee how to fill out the mail ballot, that is a significant advantage to the union. The NLRB has favored these, notwithstanding what's been happening with COVID loosening restrictions. The trends in organizing, again, you know, obviously there's some Zoom organizing because we all love Zoom, as you know. It's terrific. You're experiencing it right now, and I'm sure you're thrilled to be not doing this in person. The only thing, of course, we can't see you falling asleep, which I guess is a good thing. But in any event, the Zoom organizing is a real thing. Union organizers are using it as a way to stealthily organize. But I think more significantly, particularly in Colorado, we have a massive, massive nurse organizing effort going on in Colorado right now. The National Nurses United is involved at many healthcare systems, hospitals, organizing, and they're all doing it by private Facebook group. So most of these employers do not know that this is going on, and that's the design of the union. That is a major advantage. So now is the time to be out there engaging your employees, doing your regular training on supervisory do's and don'ts, because it is happening definitely. If you're in healthcare in Colorado, you are being organized, or someone very close to you is subject to organizing. Obviously, the other trend, it coincides with social justice movements. The labor unions are very interested in trying to piggyback, if you will, on social justice movements and say that we're part of this movement too. We're part of Black Lives Matter. We're part of Me Too. And frankly, that is sort of something that happens sometimes in organizing, that it becomes like a political litmus test. And what's important for us to remember is that it's not that union representation, for those of us who've been represented by a union, those of us who've defended it, it's a very different thing. Collective bargaining is an uncertain process, and it is a practical decision that your employees need to have the facts about. It has nothing to do with politics. So try to divorce that. Not to make you more concerned, but the general counsel at the NLRB is already saying that they're going to recognize that other social justice activity is protected under their law. In other words, they're going to try to facilitate this harmonizing that the union movement is trying to accomplish with social justice movements, to get out there, organize people, and in some cases, frankly, I would imagine shame people into signing up, because this is something that labor has been very upfront about trying to do, notwithstanding labor's sort of ignoble past with respect to social justice. So we're going to move on from that parade of horribles to a discussion of some notable cases that James is going to take the lead on, and then I'm going to interrupt him just to sort of break his rhythm if I can.
Thank you, Patrick. Patrick and I just wanted to give everyone a quick heads up about a couple of decisions that have come out in 2021. While there hasn't been anything groundbreaking as we had seen in 2017, 2018, and 2019, there are still a few notable cases. And the first one that I wanted to discuss was George Washington University. And this case is a failure and refusal to bargain case, and represents this trend that Patrick and I have been seeing, where regions are attempting to limit employers' legitimate and good faith bargaining proposals. For example, advancing a proposal that may result in fewer rights than employees had before. And those have always been legal and lawful for as long as, I don't have as much experience as Patrick, but those are generally seen as lawful. But fortunately for employees in George Washington University, at least at this point, the board has reversed that ALJ's decision and found that the employer's proposals in this case were clearly lawful and a result of normal bargaining.
I think you just called me old, James, but I'm not going to gloss over that for a second. I think the other thing that's interesting about this case is that the union representative, that the the judge completely disregarded. The union representative was cursing at the employer representatives in bargaining, was saying, you can imagine the parade of profanity that came out, just saying that these are terrible proposals and insulting the employer and just being super aggressive. And the employer was just trying to, bargain in good faith and get givebacks on certain things, and also pursue a bargaining strategy, hard bargaining. We're seeing in a couple of cases that are under investigation with the sort of newly enlivened board, that the NLRB is really getting into the meat of our proposals and say, well, why would you propose that? Here's a newsflash for the NLRB. They're not supposed to be judging the subjective acceptability of proposals in bargaining. That's not their job. Their job is to regulate the rules of the game, not dictate content in bargaining.
So while this is a good decision for employers, Patrick and I anticipate to see this trend of attempting to limit employers' rights during bargaining to continue at the region level and when the board turns over, perhaps even at the board level. Next is the IKEA decision, and this is a representation case. And in this case, the employer made a technical error by not filing a position statement on time, and thus they were precluded from litigating the scope of the petition for unit at the pre-election hearing. Because of this technical error, the region decided that it need not determine whether additional employees must be included in that petition for unit. The board, however, held that a technical error does not divest the region of its statutory duty of determining the appropriate unit in each case. And that is as clear as day in the statute. And so that is also another good decision for the employer. Next, we have, Patrick, do you want to?
I think we're running short on time, so let's keep going.
The next two cases involve the board's reversing of ALJ findings that certain work rules and work provisions were unlawful. And the board looked to its Boeing work rules test to find that the work rules at issue were lawful. And in AT&T specifically, the board reiterated that an unlawful application of a work rule does not make the policy itself unlawful.
So, I mean, obviously, many of you lived through the experience of the Obama board really going through your handbook and dissecting it. And there was all sorts of issues where, you know, any violation or a violation could be lurking in any handbook provision. These cases are important because the NLRB has reset the standard in Boeing to have a balance between protecting the right of employees to engage in union and other activities and legitimate business interests. So if you look at cases like AT&T, it talks about prohibiting recording conversation. I've had a number of NLRB trials in my career, and in a majority of them, there was that moment where someone pulled out a recording of some conversation with a supervisor. You know, it's legitimate to try to, you know, you have legitimate business reasons for prohibiting that, and the current board has taken note of that. I think the problem is going to be that the future Biden board is going to, again, turn back the clock, not because this rule is wrong or this standard is wrong, but because what's actually happening is unions have less leverage in organizing because they can't complain about unlawful employer rules. And it's a blatant effort to try to assist the labor movement in organizing.
And finally, we have Mount Air, and which is notable in that it looked at the board's contract, where the board looked at the board's existing contract bar doctrine and ultimately decided to retain the doctrine as is. And I know I kind of glossed over that last case, but I want to give Patrick the opportunity to go over kind of what we have alluded to, which is this Biden board turnover and what they possibly could be looking at it overturning in the future.
Yeah, I mean, I'm taking this list directly from a meeting that I participated in, an ABA meeting, where a bunch of union attorneys were talking about the top cases on their hit list, the cases that they wanted overturned immediately. It was almost like they were instructing the NLRB what to do. So that's always heartening for all of us, isn't it? The first is Super Shuttle, which has become the bane of unions' existence, apparently. We feel strongly about this case because it's a Sherman and Howard decision, a case that we litigated for almost 10 years. And Super Shuttle is not an outlier in terms of independent contractor. It is an application of the common law test, which has been the prevailing test at the NLRB. And it is very significant in that it points out that regulation, in other words, if you are asserting control due to a regulation, in other words, you're regulated in this way and therefore your employees are regulated in that way, that's not employer control Super Shuttle makes that very clear. That is going to be overturned, and I think the law may go beyond what it was before. It may go to more of a test that really diminishes the common law standard for independent contractor, because that is something that unions have decided they have to do in order to organize in other areas. And one of the things we didn't talk about at the beginning of the presentation that we should have, of course, is organizing among gig workers. And, in places like Amazon, that, the union movement has made a big splash about its intent to organize. There's been a New York State law about organizing gig workers. And of course, the Amazon campaign down in Alabama, which came down with a giant thud when they lost, like miserably. I mean, it's like not even close. But Super Shuttle is viewed as an impediment to those organizing efforts. The next case, I think, is Walmart. Walmart was an unusual case for the NLRB because it really addressed for the first time a size restriction on a button. In other words, it allowed an employer to say, your button can only be this large, even if it's a union button. And those types of restrictions have been presumptively held unlawful for many years at the NLRB. I'm not saying that makes sense at all, because it certainly doesn't, in my opinion, but it was definitely a departure that unions are very, very upset about, and they intend to get overturned as quickly as possible. And I think that maybe the biggest decision that we talked about last year is the General Motors case. And John Dorn was talking about one of the justices' comments about how the N-word is the most offensive word to utter in the workplace or elsewhere. And I think that General Motors was a case where the board finally said, yeah, it is. And in fact, it's not okay for striking workers to attack replacement workers with those types of racial epithets, or with threats, or with this aggressive language, and really kind of brought that law into the early 21st century. And what General Motors also did was it went beyond that and found that motivation is an important element in those types of cases, which I think that the overturn of General Motors could be one or twofold. The board could just overturn that employer motivation is relevant, or it could overturn the whole lot and send us back to the dark ages, where only in the labor environment do we have to tolerate the most offensive language in the workplace, which would be quite a shame. And then finally, the union movement is very keen to have McDonald's overturned, which is the case that settled the McDonald's litigation. And actually, if you want to go back one slide, the other two that I brought about, we talked about, obviously Boeing's going to be overturned. Boeing is the case that reset that logical standard for employer rules. And in Allstate Maintenance, that was the no tipping French soccer team. And Cordua Restaurants was a case where the board said that asking an employee to sign an agreement not to form a class or collective action was a violation. We expect all of those to be overturned in short order. And then finally, the McDonald's case, where the board upheld a settlement between the general counsel and McDonald's that did not resolve the joint employer issue. And really what the board said in that case was, we don't have to resolve legal issues. If the parties are happy and the settlement is not offensive to the act, then we're going to enforce it. Of course, we can't have that. We can't have labor peace. We have to have disputes in the workplace, because that's what being in a labor environment is all about, unfortunately. So expect McDonald's to go down with the rest of them. James, any thoughts on any of those?
No, I think we can discuss further if we need to offline, since our time is short. But
so thank you all, and again, thank you for joining in these odd circumstances. I don't know if we have any questions, but we can take questions after, certainly, and email us at any time if you have any questions about any of these developments, and please stay tuned, because they're going to be coming fast and furious over the next year, particularly once the Biden board gets seated. And with that, we'd like to introduce Carissa Davis. Carissa, I first met Carissa when I was asked to kind of guest lecture at her labor law class at Stern School of Law at DU. And I remember that she went after me on a number of issues and asked me questions, and I was, you know, totally flabbergasted and stuttering over myself. And at that point, I realized this is somebody we have to have in the firm because she really gets after issues, and she's taken on wage and hour issues in a way that has really enriched the entire department. Frankly, she's kept us up to date, and she has a lot of great information to share with all of you. So with that, I give you the very talented Carissa Davis.
Thanks, Patrick. Thanks, James. And I just hit Patrick with some really hard questions so that I could prepare him for these wonderful presentations that we have today. And so I will get started with the PowerPoints. We're going to be talking about wage and hour compliance today. And I understand that wage and hour compliance is perhaps not as interesting as labor developments or Supreme Court developments or any of the other issues that we're going to discuss today. But in terms of where employer proactivity, an ounce of prevention is worth a pound of cure, I think that wage and hour issues are some of the most important issues that employers can head off the potential for litigation by ensuring that they're appropriately prepared. And so today we're going to talk about three major updates at the Colorado state level: the COMPS order, the Equal Pay for Equal Work Act, and the Healthy Families and Workplaces Act. And so we're going to start with the COMPS order today. The COMPS order stands for Colorado Overtime and Minimum Pay Standards Order. And you may have previously thought of Colorado wage and hour law under terms of wage orders. So wage order 34, wage order 35, and so on. The numbers would, add up each year. We switched over to the COMPS order in COMPS 36, and it wasn't just a name change for the sake of name changes. Rather, switching over from wage orders to COMPS orders has indicated a significant change in Colorado wage and hour law. And what employers can expect in terms of the requirements imposed upon them. I'll say that perhaps probably the greatest impact switching from wage order to COMPS order, and I mentioned it was wage order to COMPS 36, now we're on 37, and then next year it'll be 38 presumably. But the biggest change from wage orders to the COMPS order is the presumptive coverage. Previously, under wage orders, only certain industries were covered. Now, under the COMPS order, every employer is presumptively covered under the COMPS order, and every employee is presumptively covered as well. There are only certain carve-outs in terms of who's not entitled to certain protections and benefits under the COMPS order, but those exceptions are very narrow, and they differ in many significant ways from federal exemptions, and we'll talk about that in a bit. There's also been other changes in the COMPS order which are perhaps not as intuitive. So for example, the broad definitions. I always give the example of time worked, which is defined as time during which an employee is performing labor or services for the benefit of the employer, including any time he or she is suffered or permitted to work, whether or not they're required to do so. And so one might think that the definition of time worked is intuitive, but when you think about how broad that is, whether or not that employee is actually required to do so, it indicates just how important it is for employers to ensure that their employees are logging the hours that they're actually working. So for example, if employees are answering emails after hours, and those employees are entitled to earn overtime under the COMPS order, this will be an area where employers will want to ensure that their employees are not performing time worked, because if they are doing it under this broad definition, then they're certainly entitled to overtime if they exceed those overtime limits, and we'll talk about that in a bit. There are also new mandates under the COMPS order as well. And so, for example, some employers weren't used to having paid breaks. Employees are under the COMPS order entitled to paid breaks. This differs from the Fair Labor Standards Act. And then I would say perhaps the greatest, the second greatest change, besides the presumptive coverage, of course, is the implementation of a salary threshold. And so that speaks to whether or not an employee is exempt. And so previously, under wage orders, an employee would be exempt if they simply performed exempt duties. Now they must perform exempt duties in addition to earning a sufficient salary. And so that structure is kind of similar to what many employers are used to under the Fair Labor Standards Act, but it's different in many important respects. And so At the outset, it's important that for employers to note that if they're operating in a state where they are covered under both a state wage and hour law and the federal Fair Labor Standards Act, they must comply with the more stringent mandate, the mandate that provides the greatest benefit for employees. And so an example would be overtime. Under both comps and the FLSA, employees are entitled to overtime if they work more than 40 hours per week. But in Colorado, employees are also entitled to overtime if they work more than 12 hours in a day or 12 hours consecutively. And so if an employer is only complying with the FLSA, they're out of compliance for the state comps order. Minimum wage differs, exemptions differ. This is another area where you need to look into the actual terminology used in the comps order. So for example, exemptions under the FLSA and comps both have executive exemptions, but they differ in terms of their application and how an employee will actually be classified as an exempt executive. I mentioned breaks and credit limits, but there's so much more under the comps order that's different than the FLSA and different than the prior wage orders that employers need to pay particular attention to. Now, one of the other major changes in Colorado wage and hour law is the Equal Pay for Equal Work Act. And it's not just a wage and hour issue, it's also an anti-discrimination issue. So I always say that the Equal Pay for Equal Work Act in Colorado is not your average Equal Pay for Equal Work Act. And the reason I say that is because there's a federal Equal Pay Act, but it's very different than the Colorado Act. Now, if you look at the definition of what is prohibited under the Equal Pay for Equal Work Act, it seems similar. However, the main difference with the Colorado Act is that an employer cannot identify a pay disparity between sexes and just say, well, this is attributable to some other reason other than sex. Rather, under the Colorado Equal Pay for Equal Work Act, an employer must point to one of these systems in order to explain away the entire pay disparity. That's very different than what's required in most states and under the federal law. And so there's no sort of argument that you can have, well, I didn't intend to discriminate against these employees. There just so happened to be a pay rate. If it's not attributable to one of these systems, then the employer is in violation of the act. Now, there are other prohibitions placed upon employers under the Equal Pay for Equal Work Act. Employers can no longer ask questions on wage rate history. And so if an applicant is coming in to apply for a position, I think many employers ask, well, what were you paid at your last job? And, how do you want to be paid here? You cannot ask what the employee was paid at their prior job, and the reason being because that may perhaps perpetuate pay disparities. Equally, you cannot rely on wage rate histories in order to justify a pay disparity that you have here. Again, you have to look to one of those factors. Employers must permit employees to have discussions on their wages, and an employer cannot require employees to, withhold wage information. Now, perhaps the greatest mandate imposed upon employers under this act is the posting requirement. Employers are obligated to post job descriptions, including a general description of compensation and benefits information. This is obviously a major change that employers are not used to, and many employers have objected to the posting requirements for compensation. And this is a very onerous requirement if you think about it. And the issue with these posting requirements is there are virtually no exceptions where an employer can get around posting the compensation and benefits information. I think many people think, well, if it's an executive position, then perhaps we don't have to post that high rate of compensation. Not so. The exceptions are very narrow. I'll give an example. There's one exception for confidentiality, but that's not just a general need to maintain confidentiality with respect to, the business needs or any other legitimate purpose. It's only applicable to the circumstance where the employer needs to maintain a confidentiality to ensure that the incumbent is not made aware that they will soon be departed. That's incredibly narrow. So if an employer thinks of the term confidentiality the way we typically use it, that's not actually what the exemption is here. The posting requirement is also applicable to job openings. And what I'll note about these posting requirements is they need to be made available to all employees regardless of their qualifications if the position would be a promotion. So the example I always give is if the CEO of a company is going to be stepping down and it would technically be a promotion for someone who, performs janitorial services, the employer is under an equal obligation to make that posting available to the janitor, as well as any other incumbent who may perhaps, be part of a succession plan where they would be placed in the position. It would be an equal violation of the act to not make the posting for one versus the other. And these postings are required for remote work as well, because theoretically the work could be performed in the state of Colorado. Okay, now moving quickly to the Healthy Families and Workplaces Act. I think many employers are used to having some sort of paid sick leave requirement, particularly as a result of COVID. The Healthy Families and Workplaces Act imposes upon employers an obligation to provide traditional sick leave, traditional paid sick leave, and also public health emergency paid sick leave. And I'll note that the public health emergency paid sick leave requirement is not limited just to COVID. Rather, the definition of what a public health emergency is quite broad. And so theoretically, there could be instances in the future where there is a public health emergency where employers have to provide this additional leave, which I'll explain in a minute. And so, if you think you're out of the woods yet, not so. There's still a requirement for this pandemic with COVID. And then moving forward, theoretically, there could also be requirements as well. And so paid sick leave is considered wages under the COMPS order. This is important because if an employer fails to provide paid sick leave, they fail to provide wages in accordance with the COMPS order in the Colorado Wage Act. The Division of Labor Standards and Statistics does not take lightly an employer's failure to pay wages when they're earned. And so the 1 hour for every 30 hours worked of traditional paid sick leave and the public health emergency leave for that matter is subject to strict requirements for that. And so what is the substantive mandate? Employers must provide 1 hour of paid sick leave for every 30 hours worked, up to 48 hours per year. Now, an employer can provide more leave if they wish to do so, but this is the minimum requirement. And I'll note that this is required for full-time employees, part-time employees, and temporary employees. And so when we work with employers to create a safe harbor policy, when they want to utilize their PTO policy to comply with the Healthy Families and Workplaces Act, we often find that sometimes these policies only cover full-time or part-time employees. Under HIFWA, every single employee is entitled to this leave. And there are particular reasons for leave that are not just limited to the common cold, where related to, for example, domestic violence and the need to seek legal services. And you may think this sounds a bit counterintuitive. There are many states that actually impose similar requirements under similarly named acts so that employees can use their paid sick leave for all of these other reasons. Like I said, not just the common cold. The reasons for public health emergency leave are very similar to, I think, what many employers were used to with the FFCRA. If an employee's child care service is closed and the employee needs to take time off work, then the employer needs to provide leave for those reasons. But I guess I'll back up and explain what the public health emergency leave requirement is just substantively. The public health emergency leave requirement is that in the event of a public health emergency, again, how it's declared is broadly, the employer must add 2 weeks of paid sick leave to the employee's bank of leave. Now, the employer can, depending on the way you structure the policy, ensure that it's only used for those PHE reasons, or you could just add it into the existing, PTO policy or HIFWA paid sick leave policy and allow the employees to use it for other reasons. But if you don't have a public health emergency sick leave policy in place right now, you still are under a requirement to do so. We are still in the public health emergency today, although things are starting to open up. And I would suspect that the public health emergency would continue for months, potentially into the end of the year. Okay, so some general reminders about wages and wage and hour law in general. Employers have to keep posting and records, and the failure to keep appropriate posting and records could result in some circumstances in an adverse inference that the employer has acted unlawfully. And of course, it's going to be incredibly difficult to overcome that adverse inference if you don't have the proper records to show that. And so the posting and record keeping obligations are, important not only to comply with the law, but to defend in the event that litigation should occur. Under the comps order, if the employer fails to post the comps order, then they cannot claim employee-specific credits for that order. And I think that that's probably one of the more nuanced requirements of the comps order that could have serious repercussions. I'll also note that if you have an employee handbook, then you're required to distribute the comps order as well. If you require employees to sign and acknowledge receipt of the handbook, then you're required to ensure they sign and acknowledge receipt of the comps order as well. That's a substantive mandate. Compliant earnings statements are also important. The comps order sets forth what needs to be included within a compliant earnings statement, and an employer's failure to provide that is a violation of the order. Enforcement. So the division can always investigate, and they have an obligation to investigate if they receive a complaint of failure to pay wages. The complaint can be filed in federal court, which can result in even more costly defense fees. Liquidated damages and attorney fees may be available. And so it's not just merely about, $5,000 hasn't been paid to the employee. In the event that a complaint is filed in court and attorney fees are awarded and liquidated damages are awarded, then we're looking at, an issue that deals with just a few $1,000s is turning into an incredibly costly event. And of course, you have to pay your own attorney fees, in order to defend yourself. And so these are some of the requirements, some of the enforcement reasons why I always say an ounce of prevention is worth a pound of cure. I noted criminal charges up here. Criminal charges may be brought if there is a willful non-payment of a higher amount of wages. But I always like to throw that in there because I think sometimes we just think these are just civil issues, but willful non-payments can result in criminal charges. And so if we have any questions, I can take them now. It looks like we're butting up against time, and I can always take questions offline. I know many of us here work with wage and hour issues, so we're always happy to help. It looks like we don't have any questions here, so I'll release you just a minute or two early. Thank you so much for joining us this morning. We're going to take a quick break, and we're going to resume at 11:05 Mountain Time. So what you'll do is you'll navigate back to the main page. You'll click on the agenda tab up at the top, and once you're there, you can scroll down and select the session you wish to join. I'm presenting later this afternoon on workplace violence, and I know we have a few of our presenters presenting this morning, also giving talks this afternoon, and some additional attorneys as well. So enjoy your break. You can also read about each of our presenters on the general information tab. There's ways that you can navigate through, read our bios, download some of our information, and then, of course, subscribe to our newsletter. We often produce blogs and advisories, and we try to keep up to date on some of the major developments in federal and state law with respect to employment, and these state wage and hour issues are always changing, and so we try to do our best to keep you up to date on that. So with that, I'll release you for your break. Thank you so much for joining us, and I will see you this afternoon.